Welcome back to the Oxendine Law Podcast. We hope you enjoyed the first 4 episodes. I am your host, Jared Oxendine, here with my co-host, Christine Palmer. And for those of y'all that don't know us, we have been practicing divorce and family law together now for like 12 years. Is that right, Christine?
Right.
And I've been doing this for 20 years. Christine's been doing it for 16 years. We have seen it all. We've heard it all. We've got stories. We've got strategies. We've got tips. And the point of this podcast is to share it all with you guys in a very fun, collaborative way. So if you have questions about anything we're talking about, feel free to send those in on all of our major platforms, and we'll be sure to get back with you. Today, we're diving into one of the most sensitive areas of family law, and that's going to be child custody and visitation. Honestly, child custody battles are some of the most challenging and emotional parts of a divorce case, but understanding your rights and options can make a huge difference in your case. So let's just go ahead and break it down and dive right in, Christine. Let's start simple. We're going to talk about types of custody. So first type of custody would be legal custody. Legal custody gives you the right to be involved in your children's lives. You can access their medical records. You can access their school records. And more importantly, the other parent is required to discuss these major matters with you.
When I'm advising a client on what does joint legal custody look like, because they'll say, I see stuff I want full custody. Now, how often do you hear that?
All the time.
Full custody. And I'll say, okay, well, we're going to be joint legal. And it's like, well, I said I wanted full. Okay. No, you don't understand. So this is where education is so important. Joint legal does not mean that it simply means that you're sharing. You each have the same rights. It doesn't take anything away from one parent that the other parent has joint legal. I think that's a common misconception that if we're joint, that somehow they're taking some rights away from me. That's not the case. It actually is giving both parties equal rights and all the rights. And you want that.
You want it, and some of the things we see most often is, hey, she's not giving me copies of the school records, or I'm not getting copies of these reports or that report, or I don't know when the practice or game schedule is. That's why we have joint legal custody, that the other parent doesn't have to do that. If you have joint legal custody, you could go out to the school and get those documents yourself. You don't need anybody to send it to you. You don't need any permission. You got the same access as your other parent does.
Yeah, not only can you go get it, but remember, as I've never had children, that's going to be big on the podcast, right? I don't give parenting advice. I give legal advice. I don't give parenting advice. I never had kids, but there's usually one parent that is just more dominant when it comes to the schedule, the logistics, the making sure kids are where they're supposed to be. And if you are that parent, you want him or her to have joint legal custody. Why? You're not the secretary. It's not your job to tell them all this stuff. You look at them and say, you saw the paperwork, joint. You know what joint means? You can talk to the coach just like I can talk to the coach. You can speak to the school just like I can speak to the school. So it really does protect you to give that other parent joint rights, because it takes away your obligation to somehow have to be their secretary and have to make sure you keep them informed. They have rights to become informed. They also have an obligation now to become informed on their own.
Well said. I couldn't have said it better. Which brings us to physical custody. Now, physical custody just means that is the parent where the children live the majority of the time. So that's the children's home base. It also usually means that parent has final decision-making authority. And this is funny. We're going to talk about a funny story in a second. But final decision-making authority means after you have mutually discussed all these major matters. So major matters are educational matters, medical matters, extracurricular activities, and somewhat religion, although that has certainly changed over the years. But you have to mutually discuss those matters. And if you can't agree on the decision, then the person with physical custody has the tie-breaking authority. Now, what I saw, I think a couple of weeks ago, and you see it all the time, I know Christine's seen this as well, is you've got somebody on the phone and they're talking about, hey, they filed a contempt action against me because I didn't allow parenting time, but I've got final decision-making authority. You know, I get to decide if they have parenting time. And I'm like, no. It doesn't mean you can deny parenting time.
Right.
It means if y'all can't agree on where your children should go to school, what sports they should play, what medical treatment they should get after a good faith discussion, then you can make the final decision.
There's very limited categories. It is not a carte blanche. You have the final decision over everything regarding this child. So yeah, I think that's a common misconception. Also, the parent without that to just kind of sit down sometimes, lay down. They don't know. They're like, oh gosh, if I looked at the paperwork, it says mom has final decision-making authority. So they don't challenge it and they don't get good advice or go ask somebody. I think most often we see that someone calls and says, how do I change final decision-making authority? And I'm like, why do you need to? And when they explain a situation like you just said, well, you know, I'm supposed to have Friday to Sunday, but she says that he has tutoring on Friday nights. So I only get Sunday, Saturday to Sunday. Okay, that's not what final decision making is. And yet this person just got educated for the first time, and they've been dealing with this for 2 years, not knowing that that's not what that means. So yeah, I think that's important too, that it goes both ways, right? You don't have it, but also that other parent doesn't have it. So just knowing what it means to have only final decision making authority.
It's amazing how many misconceptions there are out there about that.
Yep.
So then we see joint physical custody, and that's when final decision making authority would be shared.
Sure.
So,
which is a trend, preferencing toward joint, both parenting time. It's always kind of been there for legal custody. But as far as joint physical custody, I mean, we've even seen introduced, not passed, but introduced legislation that should be the presumptive outcome. You should basically have to prove it's not in the kid's best interest to have a 50-50. And we've seen a lot of judges that used to refuse to do 50-50, like it wasn't going to happen. If you see, we're assigned to judge so-and-so, probably not going to do a 50-50. Let's, try to get on something else. I think a lot of them are just trending that way now. And
and especially in a situation where you've got two parents that are involved. Now, if you've got a situation where one parent's just been handling everything, I mean, they do all the doctor's appointments, they schedule all the extracurricular activities, they go to all the activities. They're the only one that's ever been to a parent-teacher conference. The other parent wouldn't even know the children's teacher's name if you ask them. Okay, maybe that person should get off final decision-making authority. But we see a lot of situations where both parents are equally involved. And so it makes sense and it's fair. And frankly, it's in the children's best interest to split those final decision-making areas up. Mom gets 2, dad gets 2.
Sure.
And you'll sometimes, I've actually saw this in a case recently of mine, where the judge, so the parties had a 50-50 schedule and they had joint physical, and mom had 2 final decision-making authorities. Dad had 2 final decision-making authorities. The parties hated each other. They did not get along. They did not co-parent. And so somebody filed for modification saying this person is so difficult to deal with, I shouldn't have to share final decision-making authority with them. You should give it all to me, judge. And basically the judge decided, you know what? I'm not giving one parent more power over the other, because whoever gets more power is going to abuse it.
That's
and
right.
So the judge kept it with a 50-50 joint physical, right? You seen that happen?
Absolutely. Yeah. And I think that's another thing that a lot of parents come in and, it's just a highly emotionally charged time. And they're trying so hard to advocate for why they should have something that they come off as unreasonable. They're like, well, I do this and I do this. And the inverse that they start to then the narrative they create, and he does nothing. Okay, he does nothing. I mean, have you ever seen a parent that does nothing? That's rare. Do you do more? Possibly. And then also the conversation of, sure, during the marriage, he may not have taken on those duties. That doesn't mean he's not ready to step up and do that in his household. So just because he didn't do it in the past, I mean, how often, I don't have kids, but how often would 2 parents really be at a well checkup? I mean, maybe for a baby, but it's still exciting. A 6-year-old that just needs a shot before he goes back to first grade. Do y'all really both take off work and go there? I don't think so. I don't think that happens in the real world. So
you would be right. You would be right. Until you're going through a divorce, and then everybody wants to dress up for court. And hey, no, I'll take the child to the doctor.
Right.
No, well, what is it? I want to make sure I'm there.
Cleaning. Yeah, it's important that I be there. I'd like to speak to the dentist myself.
I can't believe you didn't tell me that her son had a teeth cleaning appointment this afternoon. I so would have taken off work and been there. We've seen it all. So that brings us, last thing on custody, we'll start talking about parenting time, sole custody. So sole custody is a situation where it's not joint legal. There's not a primary physical. There's certainly not a joint physical. You've got somebody that's got sole custody. That's rare, but we see it. So what is sole custody? That means you don't have to consult with the other parent. You don't have to share any final decision-making authority with them. And it means that usually they have a very limited and or supervised parenting time schedule. So we're talking about a situation where the other parent has a drug addiction or an alcohol addiction or some other serious concern that the child's safety or welfare would be harmed if that parent had any type of decision-making authority or any type of just regular unsupervised parenting time schedule,
Sure.
right? Would you agree with that?
Incarcerations, yes, recent stints in rehab. It does have to be egregious, just because, and of course, again, everyone's an alcoholic when they go through the divorce, right? If you've ever had 3 beers after dinner, you're an alcoholic now suddenly. So it does have to be something severe, and it is something that usually parents can mitigate past, except in extreme circumstances. So we really are, if you tell a client that, often you have this conversation, you explain what sole custody is. That's me. That's right there. He drinks. These things come out. I think he those Delta 8 gummies. I found those in the glove box one time. And it's like, okay, well, that's not what we're talking about. We're talking about pretty serious and egregious, like I said, incarceration or stints in rehab.
Yes,
like
drinking to the point of passing out every day. How many times you said, he drinks every day. And you're like, okay.
Do you have
How
wine
much
every day?
do you? Yes, that's exactly. It's first thing I ask, do you drink anything every day? Well, yes, I might have a glass of wine or two. Well, what does he drink? Well,
Beers?
yeah, 3 beers. 3 beers every
So
day.
your 14% alcohol wine
Full custody.
is 5% alcohol beers. Yeah, 3 to 1's pretty even.
Gotta be reasonable and realistic, folks. All right, so let's talk about parenting time. Parenting time ranges. It's starting to get more liberal. I will say when I first started practicing 20 years ago, standard parenting time was minimal.
Yeah.
I mean, if you did not get custody, you were the non-custodial parent, and you had every other weekend defined as Friday at 6 to Sunday at 6. And if you were lucky, you might get a midweek for a dinner on a Wednesday.
Right.
That was it.
Yeah.
And now it's getting expanded. I think I'm really used to seeing that actually to be the exception and not the rule.
100%. Yeah. And I think that schedule that you just explained, like, it's almost a punishment schedule. You have to be a bad actor almost to get as low as that.
And so push for that. I mean, if you're a parent that's not going to have custody for whatever reason, you may not want custody. That's okay. We'll talk about that in a second. But don't assume that you're just going to get standard minimum. I don't even like to use the word standard anymore. I'm going to call it just minimum parenting time that Friday to Sunday. We're seeing Thursday to Sunday. We're seeing Thursday to Monday.
Yeah.
We're seeing Thursday to Tuesday. Frankly, if you do every other weekend, Thursday to Tuesday, and you get Thursday overnight every week, plus half the summer, half the holidays, that's actually 45% of the time.
Right.
It's almost a 50-50 schedule. Judges, especially when parents aren't getting along, would like to see the exchange happening from the schoolhouse. You can't do that when you're doing Friday at 6 to Sunday at 6.
Correct.
So if you're doing Friday release of school until Monday return to school, then judges will justify that by saying, well, then the parents don't have to interact as much.
No
together.
one-on-one contact.
So parenting time is changing, and it goes all the way up to a 50-50 schedule. So if we have a joint physical and a joint legal situation, you usually will see a 50-50 schedule. Christine, cover all the different ways you can do a 50-50 schedule. There's a lot of different ways to structure that.
It is common. And the best news is almost all of our custody cases settle. I mean, I can't remember the last time that I had multiple cases in a row trying parenting time. And it's because if you have good counsel like ourselves, and especially if there's a good counsel on the other side, think about it. Who's better to determine what schedule is best for your kids? You or a stranger who's never met your kids? Or a stranger like me who don't even have kids, right? Like, what are you going to judge who's never had a kid? And they're like, I don't know. Tuesdays, I don't care. So really cultivating that schedule that's best for your family and your family's unique needs is important.
Well, and here's the other thing, and I give people this advice all the time. I have kids. I got 3 kids. And any parent that has kids knows that it's nice to have a break sometimes. And so if the other parent wants to have some extra parenting time and they're a good parent and your kids want to spend time with them, enjoy your break.
Yeah.
Let's not fight over a night or two. That can be your date night. That can be your me time night. That can be your trip with the girls or trip with the guys extended weekend.
Sure.
Yeah.
And to your point of the one night, I have this conversation with every client as we discuss a parenting time schedule. Please look at your children's time as quality versus quantity. How often you're like, but it's one more overnight. And you're like, okay, that they're asleep. This whole like you just said, so the Thursday to Monday is becoming probably the most common way, in my opinion, to define a weekend. Every other weekend, Thursday to Monday. I want them to come home Sunday night. Okay, why? Well, because I want Sunday night with them. Okay, so they're going to drop off, probably maybe fed, maybe not, definitely not bathed. There's homework to get ready for school. You want that? That's not quality time. That's chaos time. I don't even have kids, and I know that's chaos.
Kristen, I think you're lying. I think you have a secret kid out there. You just don't want anybody to know about that child. You know too much.
And I do become intimately involved with my clients. I'm like, talk to me about the situation at your home, because everyone is different. And so, yeah, the quality time over quantity time. I have this conversation with everyone. Don't fight over quantity time. Don't do it. Look at the quality time that you're getting. If they come home at 8 o'clock on a Sunday night, you are not having quality time with them preparing for school Monday morning. You're just not. Plus, that's so disruptive for them. Let them stay in the house they've been in all weekend. Let that parent deal with the bath and did you get your homework together? And it was that project done, and get them ready. And also, Monday morning wake-ups, I'm going to assume, are the worst morning wake-ups, right? Because you had chaos and caffeine and sugar all weekend long. Monday mornings sound kind of tough. So, yeah, let that parent deal with that Monday morning nonsense. Get them back in their routine, and then they're back with you for a Tuesday morning.
Agreed. Now let's have some fun with this. Georgia-Alabama game. I know it didn't turn out the way you wanted it to. For the record, Christine is a diehard Alabama fan. I'm a Georgia fan. But it was actually Christine's case. That's why I'm going to let her tell the story. we had a situation where she was in the middle of a mediation arranging parenting time for a case ahead of the big game. And what happened, Christine?
Right. So like he said, I'm a Bama grad, not just a fan, actually alumni, as was my client. So everyone knows that is the game of this entire season. Everyone's excited. We were all still undefeated at that point. So we're getting ready for it. And out of sheer spite, Mom on the other side of the table, we know what she's doing. She does not want him to be able to go and enjoy that Bama-Georgia game. I can tell. She's kind of sent certain things over where we know that she's trying to prevent that because it's like a standard thing for him. Him and his little college buddies, they go, they party, they enjoy that game. So she quickly pulls up the schedule and she counts the games and she says, okay, kickoff weekend, this weekend. Dad's weekend needs to start this weekend. He's going to do every other weekend. Dad's weekend needs to be this weekend. And we're like, okay, fine, sure. So afterward, she lets it slide to a friend of hers. I got one over on him. So I counted it up. He's going to have the kids that weekend. There's no way he's going to get to go have fun. Not being a football fan, completely forgot about that idle week that we both had before the big game. So that totally threw it off. It failed. He actually went out of town with the kids on the week that we were both had a bye and then enjoyed his game. And when I tell you, he was grinning ear to ear.
She had the kids during the game and couldn't have fun.
Kids. That's it.
And see, I'm still traumatized. I misspoke her. I said it turned out the way you wanted it to and didn't turn out the way I wanted it to. Apparently, I'm still traumatized from the outcome of this. I guess because our season has turned around so well since that game. Well, I love that story. So anything we need to talk about concerning what courts consider in making decisions on custody and parenting time? And very quickly, we get into these custody battles and dad wants custody and mom wants custody. And we have these ugly, nasty, knock down, drag out custody battles over who should get custody. And in my experience, at least, it comes down to who historically has been the primary caretaker and with which parent does the court think the children's best interest would be served going forward. I mean, that's kind of the legal standard.
Sure. And if you look to get super technical, if you look at the statute, the elements are A through O as to what the court must consider when they're determining what's in the best interest of the children. There's a few of those factors that really don't play into a lot of cases, like what does a guardian ad litem think? Things like that. But if you're looking at A through O of the factors, there are some that do weigh much more heavily. So I wouldn't say they're all created equal. And the one, factor N, that's the most important is which parent is going to best facilitate a relationship with that child or children and the other parent. Every judge that I've ever been before will reiterate that factor probably has the most weight of them all. If one parent is just unreasonable, stubborn, just not going to facilitate that relationship, they're not going to give primary custody to that parent because they know it's about to happen. They're about to start that alienation. They're going to be rigid. They're never going to be flexible. If we said, our parenting time schedules, what do we always say? Our hope is that you get this on paper, you throw that paper in a drawer, and you guys just work it out because you're not required to go by this if you can agree to something else. So, if dad's supposed to have an overnight on Thursday, but now the kid's in soccer and soccer's every Thursday, and dad says, can I do my overnights on Wednesday? You're supposed to be able to be flexible and do that. But if you've got that one parent that's unreasonable, that just will not facilitate an actual relationship with the other parent, cooperate and co-parent, they're not going to give that parent a full custody because they know what's going to happen. So that's the one I think that they look at the most. And that's where I think a lot of people that want custody will fall into this, I've got to have all the control. It's like they think they're building their case and they're not. They're harming their case.
Well, and at the end of the hearing, if the judge feels that both parents are created equal, then you may end up with a 50-50 joint fiscal. However, people need to know that for that to work, the parties have to live close to each other. Yes. You see that all the time where a judge wants to do a 50-50 schedule, but the parties don't live close enough for it to work. In other words, the child's got to go to school based on somebody's residence, whether it's mom's residence or dad's residence. And if the other parent lives too far away to get that child back and forth to school, in other words, the child's going to be in the car too long, then you sometimes are handcuffing the judge where the judge has to choose one parent over the other as far as primary custody is concerned.
Is a huge factor.
Now, the good news, last topic for this episode would be that custody and parenting time are always subject to modification.
That is it. They are.
Don't forget, folks, once you get that order in place, parenting, custody, child support, always subject to modification. You have to have a good grounds. You got to have a change in circumstance. I think the statute says it's got to be a material or a substantial change in circumstances or in the needs of the child or children to modify custody or parenting time. But that happens all the time. We will have a final order put in place, and then let's say a parent moves. That's a change in circumstances because that means the children are going to have to change school, for example. Or let's say that the parent gets involved with somebody of a romantic nature that's a bad apple, and they've got a history of criminal charges, or they got an alcohol problem and they're abusing the children. God forbid we see that happen. So anytime you have a material change in circumstances that's negatively affecting the children after you've got a custody order in place, just know that's always subject to modification, and you can call a family law attorney and file modification.
Right, and that's for custody. So for parenting time, if it's been greater than 2 years since your last order, you can have your parenting time changed. So you don't even have to prove that substantial change for parenting time only. The court's not going to disrupt custody by any means, but I think courts, the statute was laid out, the legislative intent, things change. And yes, to change custody, to make that big disruptive change for these children's lives, something substantial has to have occurred. To tweak a parenting time schedule for kids that are growing and becoming more involved in activities and things, if it's been greater than 2 years, you're subject to having your parenting time schedule modified.
It's a great tip. Priceless knowledge based on our combined 34 years of experience. Thank you for joining us today for today's episode. If you're going through a custody battle or you need advice, make sure to subscribe. We're on all major podcast platforms. And if you're watching on YouTube, hit that subscribe button, submit your questions. We'll answer them on the next show. Frankly, we might even get back to you sooner than that. So check us out, and we'll see you next time.